question for the House is the passage of the bill. The gentleman from 38, Delegate Lane, to explain the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, Senate Bill 10 seeks to prohibit the practice of dismemberment abortion. The term dismemberment abortion means with the purpose of causing the death of an unborn child, to purposefully dismember a living unborn child and then extract him or her one piece at a time from the uterus by use of clamps, grasping forceps, tongs, scissors, or similar instruments that through the convergence of two rigid levers slice, crush, or grasp a portion of the unborn child's body to cut or rip it off. A physician or other licensed medical practitioner may perform this type of abortion if he or she determines, based upon his or her reasonable medical judgment, that it is necessary to avert the death or avert serious risk of substantial or irreversible physical impairment of a major bodily function, not including psychological or emotional conditions. Physician or other licensed medical practitioner who performs a dismemberment abortion is subject to disciplinary action by the respective licensure board. A person who performs a dismemberment abortion who is not a medical professional is subject to the penalty for unlawful practice of medicine, which is guilty of a felony, and upon conviction thereof shall be fined not more than $10,000 or imprisoned in a state correctional facility for not less than 1 year. Mr. Speaker, I urge passage of the bill.
The clerk will read the bill a third time.
Committee substitute for Senate Bill 10.
Are there other members desiring to speak to the passage of the bill? Lady from 46, Delegate Smith.
Thank you, Mr. Speaker. I speak in favor of this bill. I wish to read to you Justice Thomas in Stenberg versus Carhart, a 2000 opinion of the U.S. Supreme Court. In the almost 30 years since Roe v. Wade, this court has never described the various methods of aborting a second and third trimester fetus. The most widely used method of abortion during this stage of pregnancy is so gruesome that it can be traumatic even for the physicians and medical staff who perform it. I will begin with a discussion of the methods of abortion available to women late in their pregnancies before addressing the statutory and constitutional questions involved. The primary form of abortion used at or after 16 weeks is known as dilation and evacuation, or D&E. When performed during that stage of pregnancy, the D&E procedures requires the physician to dilate the woman's cervix and then extract the fetus from her uterus with forceps. This little model of a fetal baby is 12 weeks, much smaller than we're talking about an abortion at 16 weeks. This is Peggy speaking, not Justice Thomas. It has a head, hands, fingers, arms, legs, all of its body functions are working. A baby grows much faster after this, so we're talking about a baby that is much larger than this. And again, Justice Thomas. The doctor grabs a fetal extremity, such as an arm or a leg, with forceps and pulls it through the cervix, tearing the fetal parts from the fetal body by means of extraction. In other words, the physician will grab the fetal parts and basically tear off pieces of the fetus and pull them out. You grasp the fetal parts and you don't know what they are. And you just try to pull it down. Simply, that's all there is to it. The fetus will die from blood loss, either because the physician has separated the umbilical cord prior to beginning the procedure, or because the fetus loses blood as its limbs are removed. When all the fetus's limbs have been removed and only the head is left in utero, the physician will then collapse the skull and pull it through the cervical canal. At the end of the procedure, the physician is left, in the respondent's words, with a tray full of pieces. It used to be this, with a beating heart. All we have left is a heart that is not beating, all the parts in little pieces. I urge you to vote for this bill.
John for the fifth, Delegate Pethel.
Thank you very much, Mr. Speaker. And I know that this is a very emotional day and an emotional subject for all of us in this chamber. But you know, naturally, none of us know how long we're going to be here. And if this is the last opportunity that I have to speak against a bill like this, I'm certainly not going to pass on it. And I know that the people that named me a champion for choice would not want me to sit here today and not say anything. You know, as I said, the remarks I'm going to make, they are very personal. And you know, Mr. Speaker, I appreciate you giving us the latitude to speak on issues in this chamber and include our personal remarks. And you know, I've been here 24 years, and I can honestly tell you this year I've heard more members call for points of order than all the other years combined. And I agreed with some of those, and I disagreed with some of them, you know, on both sides of the aisle. So I certainly hope that that won't happen today. You know, I'm sure that most of you in this chamber don't know that for 21 years I voted 100% pro-life. 100%. And I voted for the Women's Right to Know Act. I voted for the Unborn Victims of Violence Act. I voted for the Ultrasound Option Requirement Act. But you know, after 21 years, basically what some of my constituents said to me was that I either hadn't done enough or I needed to do more. And I knew they had a right to say that because this is America, where we have free speech. But I also had a right not to appreciate it because I knew that I had done everything possible for the pro-life movement. Everything. And you know, my father always told me, he said, when you get up to speak or when you're talking, you should always measure the words and think about what's going to come out of your mouth. Because when those words are hateful and hurtful, you can never take them back. And I know that he would want me to take the high road today, and that's what, you know, I will do. I will take the high road. But you know, after 21 years, I could see which way the wind was blowing across this country with bills similar to today and similar to House Bill 4588 in 2014 and 2568 last year, which I voted against, which Governor Tomlin vetoed, and then last year, veto was overridden. So after 21 years, I used to listen to a newscaster who gave commentaries. He was very conservative, and he was a Republican, Paul Harvey. And I'm sure most of you in here, especially if you're a little bit older than me or just a little bit younger, you probably listened to him also. You know, and he would give a commentary about a subject, and then at the end, he would say the rest of the story. And then he'd come back and he'd give the rest of the story. And after 21 years, I was ready to hear the rest of the story. And I contacted a lady that I was asked to contact and was told I could get the rest of the story. And I finally got enough courage to call her. I know she was very surprised to hear from me. Very surprised. And when I met with her, we had a very frank conversation about issues, many about women's reproductive health that, I didn't feel real comfortable talking about, but she made me feel very comfortable in discussing those. And I told her that I didn't know if I could ever help her, because I knew what would happen when I did. It was not what she said to me that impressed me. That did impress me, but what even impressed me more was what she didn't say to me. She never said, well, you've never voted with me for 21 years at that time, and why should I trust you now? What a classy lady. So I did hear the rest of the story, and I knew then I could make my own decision about bills. And I take full responsibility for my votes. I'm the person that presses either the green or the red button. No one else. And yes, that meeting and subsequent conversations did lead me to the most drastic change on a position in my legislative career. But let's talk about, this bill. First of all, let's talk about who's against this bill. The leadership of the West Virginia section of the American Congress of Obstetricians and Gynecologists. Let me repeat that. The West Virginia section of the American Congress of Obstetricians and Gynecologists, it says strongly urge opposition to Senate Bill 10. And that organization represents more than 225 obstetricians and gynecologists in West Virginia. And it is the leading organization of OBGYNs in the nation and also the state of West Virginia. And it says, I'm not going to read all this to you, but it says Senate Bill 10 seeks to ban the predominant approach to termination of pregnancy after 13 weeks gestation, commonly referred to as dilation and evacuation. Compared to alternative procedures, D&E has been shown to result in the fewer complications. And it goes on, it talks about science, that they believe that this approach is definitely the best. And let's talk about who else is against this bill. You know, I'm good friends with the senator who represents the 7th senatorial district from Boone. And he's a doctor. When I talked with him about this bill, and I asked him if I could use some of his comments, and he said, "Oh, yes, you can, definitely." And he told me, he said, "You know, this was the first time in my 10-year career that I voted against a pro-life bill." And he said, "You don't know how difficult that was." And I told him, yes, I did know how difficult it was, because I had been there, just like him. But he said this bill interferes strongly with the doctor-patient relationship and does away with the safest procedure in the second trimester. He went on to say second trimester abortions are extremely rare and usually only happen when the fetus is dead or severely malformed. And he said that this bill clouds the OB/GYN doctor's ability to make a good, clear decision, even to the point of losing their medical license. You know, and I know that I've read some papers here, you know, about the constitutionality of this bill. Some people feel it is constitutional and some people don't. But this bill was actually blocked in Kansas and Oklahoma, a near identical bill. I'm not going to say it was exactly a near identical bill. And on January 22nd, 2016, the Kansas Court of Appeals split evenly, 7-7, an outcome by law that confirms a lower court decision. And this bill could be reviewed by the Kansas Supreme Court. You know, so I don't know what the rush is to go out there to be like the 3rd or 4th state. I think maybe this bill or a similar bill was possibly also passed in Nebraska to possibly face, you know, major litigation and major cost. You know, I really believe that this bill let me get exactly what I want to say here. I don't want to misquote. But I really believe that the ultimate goal of this legislation is to take away women's health services one by one until no safe legal options are available to any woman who makes a decision to end her pregnancy. And there's many other things I could say about this bill, but I'm not going to do that today. You know, and I thought about all those comments over 21 years, and I never could figure out why I was getting those comments when I voted 100% pro-life. But you know, everything has a purpose in life. And I finally figured out if I hadn't have received those comments I never would have sought out that lady to listen to the rest of the story. You know, let me say that that lady's not an abortionist. She gave birth to twins this past summer. So I'm proud to stand with the ladies today that are against this bill and the men that support them. And I urge a no vote on this bill. Thank you.
John from the 67th, Douglas Skinner.
Thank you, Mr. Speaker. It's kind of hard to come after the gentleman from the 5th who said more than what most of us possibly could today, and from deep within the heart. I think we need to really understand what this bill is actually about. Doctors base their decisions on the best method of treatment based on each individual patient. It is not the place of the legislature to interfere with the doctor-patient relationship. This law would deny access for women to a standard of care that is safe. As the gentleman, the chair of health acknowledged in judiciary, this is a reasonably safe procedure. Those were his exact words. It is reasonably safe. It denies the ability to fall within what is the standard of care as developed by doctors, even when it is the best option for women. This law is focused on pushing political agendas instead of ensuring that doctors are able to provide the best individual care and expertise for women. This bill is designed to deny access to a safe and common procedure in order to make it harder for women to seek abortion care. This procedure is used in about 95% of the cases today that this bill seeks to address. There is no reasonable alternative to this that is available today. It just doesn't exist. When we questioned the alternatives to this in judiciary, we learned that one of the procedures that's being recommended isn't even being taught to med students. It is not something that OBGYNs have in their repertoire today. So what happens when you don't have a reasonable alternative to this? That means you're going to deny access to a woman's most personal decision, which she should be making with her doctor and her family, not her legislature. Every pregnant woman faces unique circumstances, challenges, potential complications. Reproductive health care providers must be able to provide their patients with the best and highest quality medical care based on their medical judgment and their patients' needs, not political agendas. This is not about medicine. This is about trying to stop a decision. This is trying to prevent access to medical care. Let's be frank, the goal of this bill and the many restrictions that have been proposed in this legislature is to eliminate access to abortion by making it too hard, too difficult for people to afford. You know, many women are going to have to travel, particularly from here in the center part of the state. They're going to have to travel out of state in order to receive the kind of quality care that they seek. It's going to be difficult, and it's going to be illegal. We shouldn't be criminalizing medicine. This is the second bill in a few days where we're creating crimes for doctors. Let's create an atmosphere of safety where the legal and personal decisions of women in consultation with their doctors and their families are protected. I urge a no vote.
Lady from 31st, Douglas Arbonne.
Thank you, Mr. Speaker. We've discussed many issues on this floor this session, some very emotionally charged. But nothing is more important than our basic human rights. Very basic. The right to life. The right to have the chance at living. As I look around this body today, I notice that all of us here were born. We were all given the opportunity to live. Why should we have the right to decide that a baby, a live baby, shouldn't have the same opportunities that we have been given? The right to be born, to live, and have a future. However, last year we passed a law allowing an abortion for any reason, and I repeat, for any reason, up to 20 weeks. I was for that passage of that bill because we didn't have any laws on the books pertaining to limits on abortion. How sad. But now we do. This bill, however, pertains to dismemberment of an unborn living baby. Again, an unborn living baby. Limb by limb. This is absolutely barbaric in a society where we treasure life. According to testimony in our committee, there are other methods of terminating a pregnancy. If the mother's life is in danger, the physician is allowed to do whatever necessary to save the mother's life. There is no question about that in this bill. But, Mr. Speaker, we are talking about a live, unborn baby being aborted by a mother who doesn't want it. Imagine the trauma on the baby, and imagine the trauma the mother will feel from that day on, knowing that she killed her own baby in such a barbaric fashion. Talk about emotional and mental trauma. These women, if they have a heart, will suffer for the rest of their lives. And we, as a society, will have to care for their emotional and mental distress. Mr. Speaker, we should do everything to protect life, especially the precious lives of our unborn babies. I urge a strong passage of this legislation. Thank you.
Lady from 36th, Douglas Guthrie.
Thank you, Mr. Speaker. I, too, want to stand up for the majority of women in the state of West Virginia and the overwhelming majority of women across this country who think bills like this go too far. Go too far. Like our education system, all they want is for legislators to stop reaching their hands into their examining rooms and dictating what they can and can't do with their doctor. Each and every year, we get further and further away from allowing women to have safe, affordable, and rare reproductive health care. Now we've brought the doctors into it, and we're dictating to doctors how they are to practice medicine. without knowing what the circumstances are of that pregnancy. You know, like the gentleman from the 5th, I hate these bills. I hate that we have to come here each and every year and have someone tell women what kind of health care they are allowed to have, what kind of health care they're not allowed to have. Because it is political. Whether you like it or not, 45 years ago, or longer, the United States Supreme Court ruled that a woman has the right to medical privacy. It was called Roe v. Wade. And so we have become incubators at the state level, incubators, to test out how we can become intolerant, uncompassionate, so that we can throw up more cases, say, look, the West Virginia state legislature said that this is okay. So let's go ahead and rehear Roe v. Wade. Well, the court, the high court, is getting ready to do that. And so I stand in agreement with the gentleman from the 5th. What is the rush? Why can't we leave this alone for 1 year? You know, like all of you, I'm a Christian too. And because of my Christian beliefs, I think that we ought to be showing compassion. And I also am intelligent enough to know that we can't prevent every child or every fetus from an untimely death. We can't prevent rape or incest that compromises women beyond belief and then re-victimizes all of those women as we tell them, that's a horrible thing that happened to you, but no, you're not allowed to terminate that pregnancy. That's barbaric. You know, a couple of years ago, I was hobbling around here on a cane because I needed a new hip. My doctor said to me, here's the procedure. First we go in and we rip and tear and cut through all of the muscle. And then we dismember your hip. And it was my choice. That's absolutely correct. It is my choice. And I would suggest to you that the United States Supreme Court over 45 years ago gave women the right to make that same choice in matters of reproduction. I think the thing that is so troubling to me about this bill is that it is designed to shock and awe. If you make it sound hideous enough, if you make it sound as gross as possible, then somehow everyone will be cowed into submission to vote for something that jeopardizes the medical practices of many of our OBGYNs. As you've heard from people who are a lot smarter than me, this really criminalizes doctors. You know, I never thought I would see the day, but this really takes the cake. I believe that this particular legislative session will go down in history as being the one session that is most intolerant, that lacks the most compassion on social issues. It is beyond measure what we are about to do to make it even less safe for women in a time when we are trying to avoid abortion by giving them the medical care that they need. I don't expect to win on this one. I have never won on any of these. But what I can tell you is that all of us in here, or all of you who are going to vote for this bill, you are in the minority. Because women want you to leave them alone. Stop picking at this. And they're watching. You know, the key word here is to make it sound sensational. We had a floor speech, or a floor activity down here the other day on something that most of us are very proud of. The bill that would allow people to donate their organs. It was one of the first bills I ever worked on whenever I got here. And I thought, what a great idea. You just put it on your license that you want to be an organ donator. And yet, over the summer, Planned Parenthood, another life-saving organization, was accused of harvesting baby parts. Now, the guy that made those charges is under indictment because all of it was a bunch of garbage. But it just depends on which side of this issue you land. Do you want to go down in history as being known as someone who can't even see the other side of the coin? The other side of the circumstances that may have driven a woman to need a termination. It's not any of your business. And yet you're making it your business. I have rejoiced with each and every one of you who have stood on this floor and talked about how they made a choice to go through with a risky pregnancy, despite what their doctors said. And you know what? That is a wonderful thing. I'm glad that happens. But for those women who don't have the economic means, who have a compromised health condition, you are taking away that right for them to make their own choice. You don't have to agree with it, but they deserve more respect than shaming them and making them feel as though they've done something wrong because they are not equipped to carry that baby to term. And so, when we should be dealing with fixing and funding PEIA and roads, here we are again, Mr. Speaker, becoming the most socially intolerant state legislature in the country.
Gentleman from the 20th, Doug Markham.
Thank you, Mr. Speaker. I'm going to read three things I want the body to consider when you vote on this bill. According to Jeremiah 1:5, before I formed you in the womb, I knew you. Before you were born, I set you apart. Then we go to Galatians 1:15. Even before I was born, God had chosen me to be his. And then we go to Psalms For you created my inmost being. You knit me together in my mother's womb. Your eyes saw my unformed body. All the days ordained for me were written in your book before one of them came to be. For those three reasons, Mr. Speaker, I will be voting for this bill and encourage the body to do the same.
Lady for the 50th, Delegate Longstreth.
Thank you, Mr. Speaker. I don't usually stand up and talk about this type of issue because it bothers me a great deal, and I hope I don't cry throughout what I'm talking about. I've always, as my colleague beside me, have always voted mainly pro-life on a lot of issues here because I thought they just tweaked something that didn't really harm a woman's right to choose. I come from a background that's very mixed and diverse on this issue, and I just felt like I had to stand up to say something and point out something that I don't think you've all looked at here today. Now, we've talked about many freedoms, many constitutional freedoms. Well, this is a constitutional freedom of a woman. There's not many women who's going to stand up for this in this chamber because it's ugly. This bill is ugly. I said this in the committee, that we put out things that became a very personal thing between a doctor and a patient. It made me sick, and it made everybody else sick too. But let's stop there, because the point is, pro-life, you want to call yourselves pro-life, everybody's pro-life. There isn't anybody here who wants to kill anyone. But the thing that you're not saying, that I've read through this bill over and over, is that you're saying, let's kill it first. What do you mean, let's kill it first, before you do the procedure? If you believe in life, why are you even considering killing it first? You're still wanting to kill the baby, if that's what you're talking about. This is a procedure, a standard of care. This is a constitutional right now that we have crossed a line. 20 weeks last year, I voted for that because I'm not sure if they felt pain. And if you believe that they feel pain now, why are we killing it first? Now, you're still crossing the line as far as I'm concerned with a patient and a doctor. But if you're pro-life, why don't you stand on what you really say you stand on and put the bill out here and say you want to eliminate abortion completely, and let's vote on it. Let the United States Congress vote on that. But don't tweak this and say that you want to save a life when you tell everyone in the committee and everyone on this floor, let's kill it first, because that's what you're doing. I will be voting against this bill, Mr. Speaker. Thank you.
Jump from 32nd, Delegate Fast.
Thank you, Mr. Speaker. You know, we have a couple of judges back in Fayette County, and one of them says repeatedly in the context of abuse and neglect cases that the government, especially DHHR, has a duty to protect children. And why is that? Because children cannot speak for themselves. And we right now are representatives of the government, and we have a duty to speak for those who cannot speak for themselves. We are talking about unborn children, living unborn children who cannot speak for themselves. We are talking about living unborn children who have fingers, who have arms, who have legs, who has a head that can be grasped with instruments. That's who we are speaking about. In Judiciary Committee, we had a guest attorney that spoke to us in the context of a legal expert, and this attorney was from the American Civil Liberties Union and was speaking extensively about the due process rights of adults, due process rights of a pregnant woman. And the question was asked, are there any due process rights for a living unborn child? And the answer given was, I can't think of any. And I think, Mr. Speaker, that is the dichotomy that we are facing here today. Are we speaking about persons or are we not? For in the West Virginia Constitution, Article 3, Section 10, it says that no person shall be deprived of life, liberty, or property without due process of law and the judgment of his peers. And if we are speaking of persons here, then those persons who cannot speak for themselves have that right to life and liberty. And we cannot just turn our back on those persons and say that they can legally, without repercussion, legally and physically be torn apart limb by limb. Our laws, statutes outside of our Constitution state that an unborn child, obviously still within the mother, if the mother is killed, murdered, there are to be 2 counts of murder there, one for the mother, one for the unborn child. The same applies for voluntary manslaughter. The same applies for attempting to kill by means of poison. So, Mr. Speaker, I believe that we do have a duty to speak for those who cannot speak for themselves. And I believe that is exactly what we are doing. We are a humane society. We are a civil society. We must prevent, as an act of government, barbaric procedures on unborn children who cannot speak for themselves. And certainly, Mr. Speaker, I urge a yes vote on this bill. Thank you.
Gentleman from 37th, Delegate Pushkin.
Thank you, Mr. Speaker. The Chairman of Health and Human Resources, please yield.
Gentleman yield. Gentleman yields.
Yes, sir.
Thanks. Thank you for yielding. I'm sorry to have you get up today, but you know more about this subject than I do. Basically, what the bill says that and I hate talking about this as much as anybody, that poison would have to be injected into the fetus before the D&E, before the procedure was made. Under this bill, there would have to be poison injected.
It doesn't say you have to do that. It's saying that if you were to perform the D&E on a live fetus, that you would probably need to terminate it first before you do the D&E. So it doesn't preclude you from doing the D&E. Now, there are medical alternatives to doing a termination also. Doesn't mean you have to inject inject some feticide or something.
But this is the most commonly used method in this for a second trimester abortion.
Yes, it is.
And so, under this bill, it'd be safe to say that on any unfortunate event where someone would have this choice for themselves during their pregnancy, and this was the doctor felt was the safest method. In order to perform that method, they would have to inject poison.
Probably, yes.
And what kind of poison did they use?
Well, there's several things you can do. You can either, for injecting poisons, you're talking about digoxin is one thing, 1 milligram of digoxin. The other thing would be potassium chloride.
What would happen if they missed with the potassium chloride?
Well, it's sort of like doing an amniocentesis. You probably wouldn't miss, but if you inject it into the uterus itself, that could be something that could get into the maternal bloodstream, and that could be a factor. But I would imagine someone that is careful enough to be able to do a D&E, because it does take a fair amount of skill to do that, would be careful enough not to inject something into the maternal bloodstream.
Is this something that is commonly taught, that method is taught now?
It's not commonly taught, but it's possible. I mean, I would be able to do it if I wanted to.
So it's not commonly taught, but you said it could be a factor. Could that factor be the death of the patient?
Well, the D&E itself could be the death of the patient.
But if they missed with the poison, could that result in the death of the patient?
The possibility if it was a high enough dosage.
And then the baby dies also, right?
Well, yes, that
so
would
you have
happen too.
The mother and
if
the child
mom dies,
both
baby
die.
dies, yes.
All right. Well, thank you. I'm sorry I made you have to get up, but you're the doctor. At the appropriate time, I'd like to briefly speak to the bill.
Gentleman may proceed.
This is an extremely difficult decision for me today, not nearly as difficult as the decision is when a woman is faced with this decision. I don't know what goes into it, whether it's because it was a rape or someone was a victim of incest, or there's medical complications. I know that that's provided for in the bill, but it's not really clear, and it creates a bit of doubt in the doctor whether or not they should use this method or that method or lose their license. And what I'm trying to say is I'm very uncomfortable making this decision for other people. Now, I know we make a lot of decisions for other people, but we're making decisions inside their doctor's office for them. I'm going to come down on the side of trusting the women and their doctors to make the right decision for themselves on the unfortunate event that they even would consider that decision. Because like everybody else in here, I'm also pro-life. Everybody in here wants to see every baby carried to term and be born healthy to two healthy parents and be raised in a healthy household. But that's just not the case all the time. So yeah, it's going to be it's a tough decision that I'm going to vote against this because of what I just heard. There could be mistakes made and it could result in the death of the patient, death of the mother and the baby. And I have a feeling though that there's going to be there'll be more votes in the affirmative, and the bill is going to pass. And I just hope that if we are all truly pro-life and we're all truly pro-children, I just hope after this vote we can work together on doing some things to improve public education and maybe juvenile justice reform, maybe helping their parents get better jobs so they can provide for their kids, maybe funding their insurance, their health insurance, so they can go to the doctor themselves. So, but it is a tough decision. I'm going to have to vote no and trust women and their doctors to make these decisions for themselves. Thank you.
John from the 10th Delegate Azinger.
Thank you, Mr. Speaker. Last week I quoted a gentleman named Ron Johnson, a theologian from Indiana, who said, "Our founding fathers called the right to life self-evident truths. This means you don't reason to them, you reason from them. You begin with life as a starting point and view all public considerations from life." Jefferson in the Declaration of Independence did that very thing. He said, "We hold these truths to be self-evident that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life." Life. Interestingly, God addressed the life issue as a first thing also. At the end of Genesis chapter 3, Adam and Eve were ejected from the Garden of Eden. And the first verse in chapter 4 records the first thing that Adam and Eve did after they were ejected from the Garden of Eden. They got frisky. It says Adam knew his wife, and she conceived. She conceived. That's called the law of first mention in Scripture. The first mention of conception, of life, is life occurring at conception. You'll find that pattern after that first verse, that verse in Genesis 4:1, repeated throughout Scripture, that so-and-so came together and they conceived and then they bear a child. Conception. That's God's standard of where life begins. We can set a standard wherever we want, in a capricious manner, in a relative manner, in our decision of where we want to decide and say where life begins. But I'd have to ask you, if you set that standard after conception, On what basis, on what authority are you setting that standard? Because God makes it clear in Scripture that He sets life, the standard of life, beginning at conception. Anything after that we do with that life in that womb, we better be very, very, very careful. Conception, a first thing. You argue from it, you don't argue to it. I said in judiciary when this was before the committee that when a nation drifts from God, this is the kind of arguments you can expect to have. Is it okay to tear apart a helpless, defenseless baby in the womb, limb from limb? Justice Kennedy, Supreme Court Justice, said of this procedure, friction causes the fetus to tear apart. For example, a leg might be ripped off the fetus as it is pulled through the cervix and out of the woman. Kennedy again in Steinberg v. Carhart said, the fetus in many cases dies just as a human adult or child would. It bleeds to death as it is torn limb from limb. That is man setting a standard that God did not give us, setting a standard of what we can do with life after conception. We think because God is merciful that God is indifferent. Or as R.G. Lee said, that perhaps He's blind, that He cannot see. Perhaps He's deaf, that He cannot hear. Perhaps He's paralyzed, that He cannot move. But He is none of the above. God bless those that made this bill happen. May their numbers increase. Mr. Speaker, I urge its passage.
Gentleman from 52nd, Delegate Schaefer.
Thank you, Mr. Speaker. You know, the things just keep getting harder, don't they? You know, I've talked to a lot of legislatures this session, and they said this has really been a tough one. And, you know, I was told before I come down that politics makes strange bedfellows. And as you sit back and as you're against someone today or against this bill, the very next bill your best buddy's on. But you know, I've heard a lot of talk here today about pro-life. I've heard everybody talk about being pro-life. And as I spoke on this bill in judiciary, I just wanted to bring up one thing. If you get down to the bottom of the bill, it clearly says, this section does not prevent an abortion by any other method for any reason, including rape and incest. I said in judiciary when I spoke on this that if I had my way, I would outlaw abortion 100%. But I guess we're going to leave that decision up to the U.S. Supreme Court to make constitutional law, like they do in every other thing. But I do want to read a couple things. West Virginia Law 61-230 talks about when a lady is murdered and she's pregnant. And in section C, it says, for purposes of enforcing the provisions of section 1, 4, and 7 of this article, subsections A and subsections C, section 9 of said article, sections 10 and 10B of said article, and subsections A, section 28 of said article, a pregnant woman and the embryo or fetus she is carrying in the womb constitute separate and distinct victims. Now, if you go right above that, it talks a little bit about embryo and fetus. And it says embryo means the developing human in its early stages. And it lists two different periods. And it talks about the embryonic period. Commences at fertilization. I think if we looked that up in the dictionary, I'd say that's when the baby was conceived. It's when two people have sexual relations and a human being is formed. And what this bill was about, as we've heard our Assistant Chair in Judiciary say, it's about the ripping off of a leg, of an arm, of a head, of a living being. Now, he has said that if they kill the baby ahead of time, that they can do this. You know, this bill does not outlaw abortion. In Judiciary, we had one of our delegates that's a physician talk to us, and he talked to us about other methods of abortion. This bill does not affect those other methods at all. All it does is try to protect that little fetus that's in the womb while it's alive from being ripped and torn apart. I also want to direct you to the 8th Amendment of the Constitution. We've talked about constitutional freedom of women. The 8th Amendment gives this right to criminals. Excessive bail shall not be required, nor excessive fines imposed. That one there doesn't apply, but it's the last part of that. Nor cruel and unusual punishment inflicted. I want you to think about a living being that is breathing and living off its mother, and you're going to go up in there and you're going to rip its legs off and let that little baby bleed to death. Do you think that's cruel and inhuman treatment and punishment towards a human being? If you do, please vote green on this bill. Thank you, Mr. Speaker.
Lady from the 51st, Delegate Pleshire.
Thank you, Mr. Speaker. Just like cases and constitutional provisions, there are competing versions of things in the Bible. For example, Genesis chapter 2, verse 7. Then the Lord God formed a man of dust from the ground and breathed life into his nostrils, the breath of life, and man became a living being. A living being. Now, we had a public hearing on this bill, and there were persons who testified from several different religious traditions, and we have different religious traditions within Christianity regarding when life begins and when it would be permissible to terminate a pregnancy. Not everyone believes the same on this issue. And let's be clear, we are not talking about a viable fetus. We've already outlawed abortion after 20 weeks, and there has been no instance of a fetus that was able to breathe, that was able to live, that's under 20 weeks old. Another scripture that I think might be helpful, scriptural verse that might be helpful in this instance, is judge not, lest ye be judged. Judge not, lest ye be judged, which is from Matthew chapter 7, verse 1. We don't know all the facts. If a woman and her family and her physician are considering terminating a pregnancy. Many families in this second trimester desperately want to have children. But they know that if they're forced to continue the pregnancy, the child will die within the first few days. For example, if the fetus has no brain, no heart, or multiple anomalies that would virtually assure that it could not survive. Yet we are going to override the judgment of a woman and her family and her doctor who says that a D&E procedure is her safest option. That's what this bill would do. So I'm going to be voting no for 3 reasons. 1, in my opinion, this bill is unconstitutional. It violates women's liberty and privacy rights because this is a very, very private decision about whether to have children or not. Most people really want to have children, and most people, it's a blessing to have children. But we should not be barging in to the doctor's office and mandating that decision. So my second reason is I think that we need to have some compassion for families during that second trimester who are going to be having to make difficult decisions. And thirdly, and lastly, we shouldn't be punishing physicians for exercising their best medical judgment. That is what the American College of Obstetricians and Gynecologists have said, is this is the safest procedure for women in the second trimester. So I will be voting no on this bill.
Lady from the 18th, August.
Thank you, Mr. Speaker. There's not much more I can say on this bill. A lot of it has already been said on both sides, but I would like to thank you, Mr. Speaker, for escorting the pages out of this chamber. This has been it's been stated that this is a horrible bill. Well, Mr. Speaker, this is a horrible practice. It's a horrible procedure. This deals with live babies in the womb, and they are dismembered while they are alive. It's been stated that this does not end abortion. Roe versus Wade still exists. It doesn't criminalize doctors. The criminal and civil penalties were removed. The high courts have determined as in partial birth abortion, another procedure that was upheld by the court, that the state may use its regulatory power to ban certain procedures. And no court has determined, in the couple of states that have passed a similar bill and legislation, no court has determined that it is unconstitutional at this time. We've heard this is about reproductive health. It's a political agenda. We've heard that it's a political agenda. Mr. Speaker, I'm glad to be political if it means that we're going to end a practice that does this to a human live baby. I don't believe this is politics. I believe that it's humanity, it's compassion. I'd like to remind the body, we've heard that this is not somebody that said this, I'm not sure, I think it was the gentlelady from Kanawha County said that this is not the legislature's business. But I'd like to remind you that Chapter 19, Article 2E was adopted by this legislative body, and it's called the Humane Slaughter Act of 1982. And it puts forth humanity, compassion in the slaughter of livestock. Yet we're debating whether we should be compassionate in the slaughter of a live baby. Inmates on death row. There's compassion and humanity in death row for lethal injections. Each state that employs lethal injection for the death penalty must have a compassionate, detailed protocol in place before they put a death row criminal to death. Mr. Speaker, I'm going to stand on the side of humanity and compassion today. I'm going to vote whether a future court will turn this over as unconstitutional. I'm going to stand today and say that a live baby deserves humanity and compassion. I urge a green vote on this. Thank you, Mr. Speaker.
The lady from the 32nd, Delegate Kessinger.
Thank you, Mr. Speaker. Safe, legal, and rare. We've heard it over and over since 1973. We've heard it in this room today, that abortion should be safe, legal, and rare. Well, out of those three words, the only thing I can think abortion is legal. It's not rare, with more than 55 million unborn children being aborted since 1973, and it's not safe. The CDC says that in 2009, the CDC said that more than 400 women have died as a result of a D&E abortion. The CDC also says that more than 40% of women who receive a D&E abortion have serious complications. Everything from lacerations of the cervix or uterus to infections to death. Death in the case in Chicago in 2009, where a young woman, 24 years old, Tanya Reeves, died just 12 hours after having a D&E abortion procedure done. She bled to death because her uterus was perforated, because a D&E is a blind procedure. In 2002, a 25-year-old woman named Diana Lopez in a Los Angeles Planned Parenthood lost her life after her cervix was punctured and bled to death in a hospital 5 hours later. We can sit here and say that this bill is going to put women's lives at risk, and we do that every single time any type of restriction or regulation is tried to be placed on abortion procedures. In 2003, when President Bush signed the partial birth abortion ban, after being vetoed twice by the former President Clinton, people said, this is going to hurt women. This is going to take women's rights away. This is going to leave women without adequate health care, and women are going to die because they can't have a partial birth abortion. Not one time since 2003 has a woman died because she couldn't receive a partial birth abortion. Last year, we passed the 20-week pain-capable Unborn Child Protection Act. And we heard these same conversations. This is going to take women's health away. This is going to put women at risk. And not one time since last year have we heard that a woman's life has been lost because she could not receive an abortion after 20 weeks. My friend from the 36 compared a fetus to her hip replacement. The last time I checked, your hip doesn't have a heartbeat. It doesn't have fingernails. It doesn't have fingerprints. It doesn't have eyes. It doesn't have a beating heart. We are not talking about just another limb on our bodies. We're talking about a completely separate individual that has a right to life and should be protected, and that's why it's our business. It's been asked, it's been said that it's none of our business to get involved in women's health. Well, let me tell you, a fetus it's not just another part of a woman's body. It's a completely separate entity, and if you believe life is inherently valuable, then you believe that. I'm not going to sit here and say that any of my friends in this room, whether you vote for or against this bill, are pro-abortion. I don't think anybody but abortionists are pro-abortion. We all value life in all of its stages. And I'm asking you today to look at the humanity, not only of the fetus who's being ripped apart limb by limb, but even the risks that these procedures present to women. You know, I don't want to be too vulgar, but I do want to read something from a former abortionist who has since laid down his abortion tools. And it says, the toughest part of a D&E abortion is extracting the baby's head. The head of a baby that age is about the size of a large plum and is now free floating inside the uterine cavity. You can be pretty sure you have a hold of it if the sofa clamp is spread apart about as far as your fingers will allow. You will know you have it right when you crush down on the clamp and see the white gelatinous material coming through the cervix. That was the baby's brains. You can then extract the skull pieces. Many times a little face will come out and stare back at you. Congratulations, you have just successfully performed a second trimester suction D&E abortion. You just affirmed her right to choose in less than 15 minutes. 15 minutes, that's all it takes to rip a baby apart, a baby with a heartbeat, a baby with fingerprints, a baby with its own completely separate own set of DNA. And so I'm asking you, Mr. Speaker, and members of this body, to think very hard about the decision that we're making. And I would urge a green vote on this bill.
Gentleman from 53rd, Delegate Smith.
Thank you, Mr. Speaker. I feel it's sad that our society has got to the point that we have to even pass a bill like this, that we've lost our heart and soul for mankind. I honestly believe if this was an animal bill, if we was talking dogs or cats, this bill would pass 100% unanimously out of this body. I truly believe that. I truly believe that. This is simple for all of us. It's simple for, this vote is simple for everyone in here. If this does not bother your conscience, if this does not bother your conscience at all, dismembering a baby, vote against it. If you have no conscience on this, if this does not bother your conscience, vote against it. But if you have a conscience, if you have 1 ounce of conscience on something like this, if this truly bothers you, then you're going to vote for this bill. It's just as simple as that. And I can tell you, Mr. Speaker, my conscience will not let me vote against this. Thank you.
Gentleman from the 27th, Doug Ellington.
Thank you, Mr. Speaker. Full disclosure, I testified to Judiciary Committee the other day, and the gentleman from the 67th asked me if I belonged to West Virginia ACOG. I do belong to ACOG itself. Some of my dues do go to West Virginia ACOG. I've never formally applied to them, but I assume that I am probably a member, or at least on the rolls. So I misstated that previously, saying that I wasn't, but I may be. So getting that out of the way. I have, over the weekend, while each of you were diligently going over all the other bills, while I was taking care of my practice delivering a few babies, I took the time to read over the ACOG practice bulletin. I was able to log on to the site and look at all the different reviews. And from ACOG practice bulletin 135, this is the most recent one, it mentions, though, that these guidelines, this is quote, these guidelines should not be construed as dictating an exclusive course of treatment or procedure, unquote. I wanted to give you a little bit of facts first, just so the members here have some background. They've heard different numbers, but I wanted to state some of the things that came right out of that committee opinion. About 4% of abortions occur from 16 weeks or later. That's what's in the second trimester. So you're only talking about 4%. After 21 weeks, 1.3%. Mortality rate, meaning mother dying, is 0.6 out of 100,000 abortions. Childbirth, 14 times greater than what it would be for abortion, just to put it in perspective. Now, abortions that are performed less than 8 weeks, the mortality rate is 0.1 per 100,000, but over 21, or at 21 or over 21 weeks, 8.9 over 100,000. So there's a relationship between how many weeks of gestation to what the mortality rate is. So the further you get, the higher the rate. Most of these terminations that are done in the second trimester have a higher rate. Now, in 1973, when they mentioned the Supreme Court decision in Roe versus Wade, the same committee report quotes, by the late 1970s, researchers had demonstrated the safety of D&E and concluded that it was safer than the medical abortion techniques used at that time. This is in the late 1970s. They also mentioned afterwards, under methods that, quote, both surgical and medical methods of pregnancy termination can be used in the second trimester, unquote. And also, quote, limited evidence suggests that the vast majority, 95%, as quoted by the gentleman from the 67th, of second trimester abortions in the U.S. are performed by D&E. However, terminations by medical abortions may be underreported. As the lady from the 51st had mentioned, that a fetus that may have no head or no heart, or no brain or no heart, most of the cases of medical abortions are performed to keep the fetus intact so as to determine what anomalies or genetic malpresentations were there. So there are reasons why these are done that way. Now, again, it does take a certain part of skill to do a D&E, and many places do not train their providers in how to do that. About 30% of residencies don't have opt-outs for abortion procedures, and about half the residency programs don't even train their residents in how to do a D&E. So it does take a certain level of skill. And as some other people have mentioned, there are significant risks to those procedures. Now, ACOG and West Virginia ACOG, along with the AMA, don't like any interference with the physician-patient relationship. And I, for one, don't particularly like it either, but I realize there are guidelines we have to go by. Main concerns regarding abortion are access to care, facilities that are available, people that are trained to perform the procedures, transportation to and from these centers, cost, insurance, just to name a few. I will submit to you that the physician-patient relationship with someone obtaining an abortion, they're usually meeting that person for the first time, so it's usually not a long-standing relationship. That doesn't negate the physician-patient relationship, but again, it's not something that's usually been long-standing. Now, government interference in medicine, particularly to my practice, Perinatal Partnership and ACOG are already pushing that we can't do elective deliveries before 39 weeks. And CMS regulates that we have to have certain codes, diagnosis codes, in order to do that. That takes a lot of the decision-making out of my hands when I'm trying to determine the general scope of what's happened with my patient. I live by that. I have to go by it. That's part of the rules. But don't doubt for a minute that if I felt I had to intervene, I wouldn't do so. And I suspect that many providers that may do abortions for their patients wouldn't hesitate to do the same and suffer the consequences. Tubal ligations. Medicaid patients, the federal government dictates that we have to wait 30 days, have a consent on the form that they signed 30 days before we could do a tubal ligation. They require that. That's because of the person's right to their privacy as far as their reproductive abilities. However, if I'm doing a C-section on someone and they wanted a tubal ligation and I didn't have those forms signed by the government, I couldn't do it. Even if it's against my best judgment, I'm subjecting that person to another procedure, something that I didn't plan on doing. Cloning, researchers, we have moral boundaries as far as what we're allowed to do from research. Euthanasia, how many patients that I've had to deal with in oncology, cancer patients. I mean, I've been faced with that. You're not allowed to do that. We set those boundaries. So my thought is there are things that we are setting. For this particular procedure, all this is saying is that if you have a live fetus, you're not going to dismember it. Now, this was brought up also about the term dismemberment. It's not a medical term. In the same bulletin, they describe it as disarticulation, for those of you that want to be specific. In any case, all this is saying is that you have to either terminate the fetus before you perform the abortion, or you use another technique. And the same bulletin reports the different techniques on how you can terminate the fetus. So this bill does not prevent someone from doing that. Certainly someone that is going to terminate the fetus is not going to be against injecting potassium chloride or digoxin into the fetus. So I don't see that this is a boundary. It does give the medical exception as far as emergency, that you can still do that. I don't have a problem with it. I know some of my colleagues do, but as I mentioned in the judiciary testimony, they didn't poll me. And I'm sure they didn't poll many of the other members of ACOG in West Virginia. Thank you, Mr. Speaker.
Further members desiring to speak for, I recognize the gentleman from 38th, Elliott Lane, to close debate. Gentleman from 38th.
Thank you, Mr. Speaker. Ladies and gentlemen, I just want to touch on a couple of things about exactly what the bill does, what it doesn't do, and then sort of provide a lay of the land as best as I can with regard to the state of the law and some court cases. First of all, I heard a couple of things mentioned in debate. One of them was that it criminalizes doctors. The bill before us does not criminalize doctors whatsoever. There is no criminal penalty in the bill for doctors who perform a dismemberment abortion. They may be subject to licensure action because they're determined by the language of the bill to be practicing outside the scope of their practice. However, as we just heard from the Chair of Health, there are numerous other areas where the government has defined what the scope of practice is for not just OBGYNs, but other medical professionals, and in fact, other professionals altogether. And I would just on that point point the members to a United States Supreme Court case, Washington versus Glucksberg, which says that the government has an interest in regulating the profession of medicine. The government has an interest in regulating the profession of medicine. And so from the United States Supreme Court, they have certainly recognized that we have, as legislators and policymakers, have the ability to set the scope of practice for the practice of medicine. Another item that I heard mentioned was that women are not going to be allowed to have an abortion if this bill passes. And that's just simply not the case. If you read the plain language of the bill outlaws or prohibits one particular type of abortion, one particular type of procedure for abortion. And I would suggest to you that it is much like a recent Supreme Court case, Gonzalez v. Carhart, which was a 2007 case that upheld the partial birth abortion ban. In that case, the court determined that this one particular procedure, the legislature or the Congress at that level had the authority to prohibit that particular type of procedure. And in the bill before us, the language seeks to do the same thing, and that is prohibit one particular type of procedure. Now, one of the requirements under the Carhart case was that there are alternatives to the procedure that was banned under the statute in that case, the statute in this case. I think we all heard, if we were paying attention, the Chair of Health just described the alternatives that are available even if this bill is passed and becomes law. There are a number of alternatives that are available to provide a woman the opportunity, if she so chooses in consultation with her doctor or if medical necessity requires, that pregnancy be terminated. And so while we have some information from particular groups or particular doctors who are opposed to it and claim that there's not a medical necessity, that there are no other procedures, we also have conflicting testimony and conflicting evidence and conflicting argument presented to us, both at the public hearing that was held, in the Health Committee, in the Judiciary Committee, in documents provided to those committees, and by our friend from the 27th, who is, as I might remind the members, an expert and is practicing in the field. And so when it comes to conflicting medical testimony as to whether something is necessary, whether it is available, whether or not there are alternative procedures, what does the court say in that regard? And I would point the members to the Kansas v. Hendricks case, which is, again, a United States Supreme Court case. And part of the holding in that case found that the law survives where medical uncertainty exists. And so in that situation, and in Gonzalez, you had exactly the situation that we've been presented with here today, which is medical experts. Some said it was a good idea, that it was available, that it wasn't available, and then there were others on the other side. So you had medical experts on both sides presenting their arguments, presenting their facts. And so when that happens, the court has said that the law will survive constitutional challenge where medical uncertainty exists and the legislature acts. I would also just point out, with respect to the practice of this procedure, we've heard that ACOG and some of the other groups have opposed it, and that the procedure is not taught, it's not available, and people don't know. I have as part of the information that was submitted during the public hearing and to the Judiciary Committee when we took this up, a letter from the professor and vice chair of the Department of Obstetrics and Gynecology at WVU here in Charleston. And as you may or may not know, Charleston's medical school has a division here in Charleston where students can take their residencies in the local hospitals. And so this person is the professor and vice chair of that OB/GYN department here through WVU here in Charleston. I won't read the whole letter, but I will point out 2 sentences I think that are important to our contemplation today of the bill. And he says, "Never in my 30 years of medical care has an obstetrician gynecologist and over 25 years of maternal fetal medicine has it been necessary to dismember a living baby." He goes on in the letter to say, "Virtually everyone abandoned these dangerous surgical procedures precisely because of the risks to the mother with regard to laceration, damage to internal female organs by fetal bone, shards, instruments, and significant risk of perforation of the uterus." And he also talks about the availability of medications that are relied upon to terminate the pregnancy prior to dismembering the fetus and extracting the fetus. And so I believe that based on the information that we've been provided from the medical community, there's clearly alternatives available to this procedure. Based on what we know from the Supreme Court, we clearly are able to enact policy and legislate when there are alternatives, and we have the authority to regulate and define the scope of practice for the medical community. Now, I heard someone early on talk about 2 other states that had adopted this or similar language to this, and that, if I wrote it down, I tried to quote it exactly. But in that discussion, in those comments, the member said that a 7-7 split confirmed a lower court decision that it was unconstitutional. And most of us who are lawyers in the room know that that is not what a 7-7 split of an appeals court does. That's not the legal effect of that. But for those who are not lawyers, a 7-7 split or any even split on an appeals court does not confirm the holding of the lower court. It simply does not have that effect. The effect of a 7-7 split or any split, even split, on an appeals court is to allow the lower ruling to stand. It allows it to stand. So that split, that even split, has no effect in the law. It provides no precedential value. And if you think about it, we've heard recently with the death of Justice Scalia that the Supreme Court now is at what some people believe is a 4-4 split. And there's been a discussion about what happens in the next year or however long it takes if there's no Supreme Court justice appointed and all of the cases that are currently before the court come out as 4-4 splits. And if you ask any lawyer, any legal expert, they will tell you that every one of those 4-4 splits has no legally binding effect on the law. It's basically a stay. It's a hold. This is where we are until we get another justice, until we can deal with this issue again later on. So the law may be different depending on where the split occurred, what circuit it came from. And I would point out that the even split stays that were referenced and that I've just explained are not in effect and should have no bearing for a second reason. First of all, they don't create law, they don't confirm the lower court ruling, but secondly, because those are not federal court rulings. Those were state courts that determined that. And so, to my knowledge and in our research, there's been no federal court that has ruled upon whether or not this is unconstitutional. No federal court has determined that this is unconstitutional. Now, I think some of the things that are important to understand is what is required for a bill that deals with abortion to be constitutional. And the reason that I say that is because one of the other comments that I heard was that the language in here says that it prohibits dismemberment abortion for the purpose of killing the baby, killing the fetus. And someone lamented the fact that all we had to do was kill the baby first, and then you could dismember the baby. And the question was raised, well, why, if we're pro-life, if somebody is pro-life, why would you not just run that bill out? And why is it okay to kill it first? Why kill it first? And the answer to that is that it is unconstitutional otherwise. Because clearly, women have a right to an abortion, and it's just a matter of where the state may exercise its authority. And so if the bill comes out that says there is no abortion, abortion is outlawed totally, then I think everybody would agree that that would be unconstitutional. And so the answer to why kill it first is because there must be an opportunity for a woman who is needs her life or health protected, or who is in a medical emergency, to have that alternative. And those are provided in this bill. And I would just point out to the members that Justice Kennedy, who is sometimes thought to be the swing vote on issues such as this, said in a case, if truly necessary, and this is upholding partial birth abortion ban, if truly necessary, in some serious circumstances, a prior injection to kill the fetus allows a doctor to perform the procedure. And so again, if we think about in the context of what has already been upheld, partial birth abortion ban, a particular procedure where there are remaining alternatives, compared that to what the language is before us, a prohibition against a particular procedure. There are alternatives that are still available to doctors and women. The life, health of the mother is protected in the language of the bill. And the medical emergency exists, and the only thing that this bill does is to outlaw a particular procedure that is for the purpose of killing the unborn child, for the purpose of killing that child, that it is dismembered. Now, ladies and gentlemen, I've tried to run through as best I could most of the arguments that I heard that were either based on the language, inaccurate reading of the language before us, or based on what I consider to be inaccurate expositions on what the case law is. I will not stand here and presume to tell you what policy you in your heart should adopt. I won't do that, because I don't think it's right for me to do that on such an important issue, such a personal issue. But I would hope that after hearing the arguments or the explanations that I've provided to you, I would hope that you would be free from the constraints of trying to figure out what the bill does and whether or not it is constitutional or not. And so that those two items have been removed, and what's left is for you in your heart to determine whether or not this is a proper policy that you believe ought to be adopted by the state of West Virginia. Don't vote no because you think it's unconstitutional. Don't vote no because you think that somebody's not going to have an abortion if they absolutely need one for medical reasons. Don't vote no because you think it prohibits every type of abortion available, because we've talked about those. None of those are valid reasons. If you truly believe in your heart as a policy matter that you should vote no, then do that. I won't tell you otherwise. I won't ask you to do otherwise. But if you truly believe that the state of West Virginia has a proper role in protecting these children in their mother's belly, I would ask you to vote yes. Thank you, Mr. Speaker.
Question before the House is the passage of the bill. Those in favor will vote aye. Those opposed will vote no. Clerk, prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, 86 ayes, 13 nays, 1 member absent not voting. Majority of members present having voted the affirmative, I declare the bill passed. Clerk.